And greetings. Welcome to Law of Evidence, the continuance of condition or state of facts from American Jurisprudence. Checking in here to make sure all the audio is clear, and we'll get started. And of course, as we go through the presentation, we'll of course have Black's Law Dictionary, 9th edition at our side to make sure we leave no word behind. That said, let's proceed. On to Chapter 12, the continuance of condition or state of facts. This is again from the American Jurisprudence volume on Law of Evidence. Section 291, generally. Before we get started with General Lee here, just remind everyone that this is strictly for the entertainment educational purposes of the broadcast of YouTube channel and not to be used misconstrued for any other use, misuse, legal, lawful, personal, private, business, tax, financial, or otherwise. Please don't do this at home. All right, let's proceed. Just a moment here. Okay. Let's get that there. And now we should have a nice stream going here. When the existence of a condition or state of facts is once established by proof, an inference or rebuttable presumption arises that the condition or state of facts continues to exist as before until the contrary is shown. So this is establishing the existence of a condition or state of facts will continue unless there is some type of contrary evidence shown here. Such inference or presumption is not a rule of law to be applied in all cases, with or without reason, but rather it calls for the exercise of sound discretion by a trial judge according to the likelihood of the persistence of a condition or fact under the circumstances of the case at bar. In general, with the lapse of time, such inference or presumption loses probative force. So over time, you could say it almost ripens there in a way. Accordingly, the only rule that can be formulated as to when the inference or presumption of continuance will arise is the broad one, calling for a discretionary determination in which the nature of the subject matter and the time interval must figure prominently. So breaking this down here, let's look at footnote 11 and see if there's anything here that would further elucidate this. Let's see here, we have footnote 9, footnote 10, footnote 11. Now we just have some cases, but we could read up on some of the footnotes we have here in the previous ones. Proof of the establishment of a highway raises a presumption of its continuance. That's a good example. Placing the burden of proof of abandonment of a portion thereof on him who asserts it. Wow. A blockade once established and duly notified must be presumed to continue until notice of discontinuance. So yeah, that's blockades. We haven't seen those in quite a while, have we? Nonetheless, once established the blockade and once it's established and duly notified, it must be presumed to continue until notice of discontinuance in the absence of positive proof of discontinuance. A foreign law proved by a governmental publication is presumed to continue until the present time in the absence of proof to the contrary. Wow. Proved by a governmental publication. Wow, you have to pull up a newer one. That's why revisions count. A quorum shown to have been present will be presumed to continue present at proceedings taken the same day until the contrary is shown. So if anyone sneaks out, then that would have to be noted. Otherwise, it could be presumed that nobody snuck out. You can see how that one's been used quite a bit in North Carolina. And then the presumption that conditions, there's a good one here. The presumption that conditions once existing continue until they are shown to have changed is no more than a common sense inference, as strong or as weak as the nature of the surrounding circumstances permits. Wow, common sense. Who would have thunk? All right, let's get back to the text here. The inference or presumption of the continuance of a condition or state of facts is a rule of evidence. Okay. It has been held to be subordinate to the presumption of innocence. It's subordinate to the presumption of innocence, and given the inviolate nature of the presumption of innocence, there is authority that the presumption of the continuance of a state of facts, once proved, does not apply in criminal cases. Interesting. That's 14. If you have some references on that. Oh, geez, pass right by it. Just this case here out of Georgia. All right. I wonder what the details were of that case. Nonetheless, let's see here. Footnote 8 was holding that it will be presumed that states, upon their incorporation, will continue the system of prior appropriation that has prevailed theretofore, and make no changes other than those necessarily implied or expressed. Greyhound lines. All right, holding that a healthy condition of livestock will be presumed to continue over a period of a few months in the absence of evidence to the contrary. Okay, we read that one. That means we're ready to go on to section 292. And if you haven't already, please make sure you hit the like. Make sure we get some notifications out there. Seems like the notifications are really slim today. And let's continue. We're on to business, property, and financial matters. The rule that a condition or state of facts, once shown to exist, is presumed to continue to exist, has been applied. See, that's footnote 15, that's section 291, we just read. So that's a federal rule of evidence. The rule that a condition or state of facts, once shown to exist, is presumed to continue to exist, has been applied so as to raise a presumption or inference as to the continuance of an occupation or business, or of the status as an independent contractor previously established by proof. So we need the proof first, then you can apply the presumption or inference. Where one engages in a business or profession without a license or permit as required by statute, an inference or presumption arises that such illegal activity continues to exist. Isn't that interesting? When one engages in a business or profession without a license or permit as required by statute, an inference or presumption arises. Key words. Let's continue. The condition of an instrument, once proved to exist, is presumed to continue until a modification or addition is proved. Footnote 19. And park-in theaters. Wow. That's an old one there, huh? All right. Again, this text here is from 1998. So, although it is rather old, it is still relevant due to the fact that this is the law of evidence, which hopefully in the sense of American jurisprudence isn't really open to frequent revision. Let's continue. Condition of an instrument, once proved to exist, is presumed to continue until a modification or addition is proved. It has also been held that a heavily encumbered condition of real estate will be presumed to continue unless something to the contrary appears. Heavily encumbered condition. I think that's referring to a clouded title, perhaps. Footnote 20. Well, we just have the case there of Vermont. And where personal property is situated in a specified county immediately prior to the time a mortgage on it is recorded, it is presumed that the property is in such county on the date on which the mortgage is filed for record. The rent charged for the lease of property at a particular date does not give rise to an inference or presumption that such is the rent for such property many years thereafter. Nor is the defective condition of property at a particular time presumed to continue to exist, at least where such defective condition is of a very temporary character. And the presumption of continued conditions does not apparently overcome the presumption of solvency. Wow. And here we go. Let's see, that's footnote 24, section 277. Let's take a quick digression to 277, see what that was. Solvency. The law presumes solvency rather than insolvency. Insolvency may, however, be inferred from the circumstances surrounding a transaction. Before we go further, solvency, although we may be familiar with the definition, we should be more familiar with a legal terminology. And the only way we could do that would be to reference a law dictionary such as Black's. So let's do that. And let's look up solvency, which is going to be in the S's. Bear with me as this is a image scan document. It takes a long time to get to the end of it. But as we do, we can serendipitously find some other, like quasi-tenant. Quasi-rent, value over and above one's opportunity cost or next best alternative, the excess of an asset's value over its salvage value. Wow. Next best option. Interesting concept here for quasi-rent. All right. So once it catches up with us here, it'll move a lot faster. A lot of good quasis there. Quasi-trustee. All right, so we need to get to the S's. R. There we go. Slamming. Slander per quad. All right. Smurf. Person who participates in a money laundering operation by making transactions of less than $10,000. Where do they get that name? Drives from a cartoon character of the 80s. Social contract, 1837. The express or implied agreement between citizens and their government by which individuals agree to surrender certain freedoms in exchange for mutual protection. An agreement forming the foundation of a political society. The term is primarily associated with political philosophers such as Thomas Hobbes, John Locke, and especially Jean-Jacques Rousseau, though it can be traced back to the Greek sophists. This is a pretty weak definition there. Nevertheless, 1837, really? Okay, so let's see here. Again, this is a law dictionary, not a historical text, although you will find some in here, but to be taken with a grain of salt. Solvency, here we go. Solvency. 18th century, the ability to pay debts as they come due. So insolvency would be the opposite, the inability to pay debts as they come due. All right. Thanks for bearing with the transgression here. Let's get back to the text where we left off. Law presumes solvency rather than insolvency, so they expect you're going to be able to pay your debts. Insolvency may, however, be inferred from the circumstances surrounding a transaction. Proof of insolvency at a particular time does not create a presumption that the same condition existed at any considerable time before that. Also, there is no presumption that an adjudication of insolvency indicates that a party continues to be insolvent. Interesting again. Illustrative applications of the rule include that an endorser was presumably solvent, that a judgment debtor is presumed solvent, and a judgment is worth its face value. Interesting, a judgment is worth its face value. That a criminal defendant is presumed solvent under a statute providing for the appointment of counsel. Wow, Florida. Among conflicting authorities noted in Childs versus State. And that, for the purpose of contribution, joint tortfeasors are presumed to be solvent. A bank, so long as it is a going institution receiving deposits and paying out monies in the usual way, will be presumed to have funds on hand with which to pay the checks of its depositors in the usual manner. As to the presumption of solvency in a fraudulent conveyance case, see section 37 or 37 AmJur, section 218, fraudulent conveyances, which we did go over in a previous live stream. All right, so we're back on to where we left off. Okay. So we dealt with that section 277. That was footnote 24. So we're done with this section here. Read that sentence once along. And the presumption of continued conditions does not apparently overcome the presumption of solvency. Now this is interesting here. So the presumption of solvency, that you are able to pay debts as they come due, is a higher presumption than the presumption of continued conditions. Let's see here, footnote 60 is holding that proof that a defendant was doing business in a county as a common carrier only a short time prior to the filing of a suit against the defendant as such is sufficient to raise a prima facie presumption of his doing business as a common carrier in such county at the time the suit is filed. Okay. And we're on to section 293, ownership and possession of property. Ownership and possession. Why they have those two words referring to property? Let's find out. Title to or ownership of property shown to have existed in a particular person is presumed to continue to exist until such time as it appears from the evidence that such person was divested of it by his own act or by operation of law. The weight of such presumption is affected by factors as the length of time that has elapsed, the character of the property as saleable, consumable, or perishable, and the character of the alleged owner as thrifty or extravagant. Wow. Inasmuch as possession is a fact continuous in its nature, it is, when its existence is once shown, presumed to continue until the contrary is proved. Interesting there. Let's see here. We just have the cases cited. Okay, 25. All right, yeah, just a lot of A lot of different cases on this one. So this is title to or ownership of property, right? Presumed to continue to exist until such time it appears from the evidence that such person was divested of it by his own act or by operation of law. So there you go. A lot of cases to look up here regarding that if you want to see some more details. But now we're on to section 294, the value of property. The presumption of the continuance of a condition or fact has been applied to the matter of value of property. Such presumption is clearly not conclusive, but is deemed relatively weak and becomes progressively weaker with the passing of time. Now we're on to section 295. Oh, yikes. Sanity. In the absence of proof to the contrary, a person is presumed to be of a sound mind at any particular time, and the condition is presumed to continue to exist. Thus, where sanity is shown to have existed just prior to and immediately after the commission of a crime, it is presumed to have existed at the time of the act, in the absence of evidence to the contrary, like that temporary insanity plea. Let's see here. Competency and freedom from undue influence shown to have existed are presumed to continue until the contrary is shown. So you see this recurring theme here regarding conditions is that they would be continued, presumably continued, until there's evidence to the contrary. All right, now we're on to insanity or mental incapacity, section 296. Whether a presumption of the continuance of insanity or an unsound mental condition will be invoked depends upon the character of the mental condition. It is generally held that the presumption arises only where the earlier insanity shown by the evidence was permanent, chronic, or of a continuing nature, and not merely temporary or spasmodic. Footnote 33. Really? This is a good one here. Okay, so it's going to be footnote 33. Let's continue. That was footnote 33. Okay, here we go. Proof that the defendant was afflicted with permanent insanity, as distinguished from temporary or transient insanity, prior to the commission of the crime charged, will raise the presumption that his insanity continued to exist until the time of the commission of the crime. Holding that there was no presumption of continuing insanity except where the defendant's prior insanity was permanent and incurable, the court in Commonwealth ex rel. Mulligan versus Smith noted that in the present case the realtor's insanity was not permanent, since he was admittedly sane at the present time and had been for years. Annotation: presumption of continuing insanity is applied to accused in criminal cases. All right. Yikes, this one's pretty dark. All right, so we're on here. In line with the generally recognized requirement that in order to give rise to a presumption of continuing insanity, the prior insanity must have been of a permanent or continuing nature, it has generally been held that no such presumption arises from evidence that on prior occasions the accused has been subject to fits or spells of delirium tremens. Similarly, where the insanity of such a nature that, while permanent and continuing, is interrupted by lucid intervals, no presumption of continuing insanity arises. Lucid interval, that's an interesting concept there. Permanent and continuing insanity interrupted by lucid intervals. Okay. That's footnote 35. Where was that happening? Rammer versus State, Alabama. And we have the Mulligan versus Smith. Okay. We also had footnote 34 here. Where did it go? Holding evidence on several occasions before the murder, with which he was charged, the defendant, when drinking, had been subject to hallucinations, such as usually manifest themselves in cases of mania potu, was properly rejected. The court in People versus Bremer said that while in the existence of general insanity was established, it was presumed to continue. This presumption did not apply to that form of the disease known as delirium tremens, brought on by one's own procurement and passing away with the removal of the exciting cause. The alcohol, I take it? Jeez. All right. Where a person has been adjudged to be insane, or where one has been acquitted of a crime on the ground of insanity, the insanity is presumed to continue until overcome by evidence to the contrary. While a prior adjudication of insanity is not a condition precedent to the presumption of continuing insanity, such an adjudication is the most satisfactory form of such evidence. In the majority of cases where a presumption of continuing insanity was recognized, without any statement of the qualification that the prior insanity must be permanent or continuing, the court has been dealing with a prior insanity shown by an unreversed adjudication. But while the courts in one state have abandoned the requirement of showing of permanency where prior adjudication is relied upon, there are decisions from other jurisdictions indicating that an adjudication is not, of itself, conclusive evidence of the permanency of the prior insanity. Some courts have indicated that in order to justify a presumption of continuing insanity in a criminal case, it must be shown that prior insanity was of such a nature as to excuse the offense charge, or that the commission of the offense was affected by the insanity. Man, that's a pretty low bar. A number of courts have held that the existence, or at least the weight, of the presumption of continuing insanity in a criminal case may be affected by the remoteness of the evidence as to the prior insanity relied upon to raise the presumption. So that was a long time ago he was insane. So I can help in this case. It has frequently been held that the presumption of continuing insanity will not arise in a criminal case from evidence that the defendant on an earlier occasion was adjudged or declared insane and committed to an asylum, where it is shown that he was subsequently declared sane or discharged as cured. I mean, come on, really? Really? 44. Gotta see this one here. Oh gosh, Daly versus United States. Post-conviction, Iowa habeas corpus. Being first found incompetent to stand trial, defendant was held at medical facility, and director then reported that defendant had been mentally restored. Oh, what do you know? An administrative release after several months of therapy canceled the continuing presumption of insanity arising from the original commitment. Oh, wow. Oh, he's fine now. Interesting. Again, these cases, Hurt versus United States, Kitchens versus, they really have to pick these names just so they can have cases named after them. All right, let's get back to the text here. Before we get too ahead on these footnotes. All right. Jeez. Okay, here we go. However, a provisional discharge from a hospital may not be sufficient to rebut the presumption of continued insanity. So if they just discharge you from a hospital, that's not sufficient. But if you're declared sane, you are now discharged as cured and declared sane. Go out there. There is some question as to the evidentiary value of a certificate of discharge, as alluding to, with a case holding that it is sufficient to rebut the presumption of continuing insanity, but with another court stating that a discharge certificate and letter from a doctor, a doctor's note, can be considered by the jury as rebutting the presumption that the condition of incompetency had continued but no more. Oh, Lord. Doctor's note. The presumption of the continued state of insanity or mental incapacity of a person shown to have existed is not conclusive, but may be rebutted by competent proof to the contrary. The presumption is one of fact rather than of law. So the continued state of insanity is of fact. So the more facts can be rebutted by competent proof to the contrary. So none of this is conclusive. The presumption is one of fact rather than of law. So it cannot be made conclusive through law, only preponderance of facts. Where there is no presumption of continuing insanity under a state's statutory scheme, an adjudication that a criminal defendant previously was afflicted with a mental disease or defect only constitutes one item of evidence to be weighed by the jury. One item. And then they have the doctor's note too, so proof that the defendant was afflicted with permanent insanity as distinguished from temporary or transient insanity prior to the commission of a crime charge will raise the presumption. We read this one here. Okay. Well, here's a good one. The previous adjudication of the defendant as a feeble-minded person did not, in a criminal prosecution, give rise to a continuing presumption of insanity. So feeble-minded is not the same as being insane. Until there has been a judicial determination of restored competency, one who has been judicially determined to be incompetent is, at least prima facie, legally incapable of making the choices involved in such processes as abandonment, waiver, or consent. An adjudication of insanity created a rebuttable presumption of continued insanity or mental incompetency. So the adjudication of insanity creates a rebuttable presumption of the continuance of the insanity or mental incompetency, and it is a constitutional error to ignore the presumption and simply leave it to counsel to decide whether to raise any question of the party's mental condition. Wow. A bona fide doubt as to a defendant's present sanity is not necessarily raised by a prior adjudication of mental illness unless it appears that the insanity was of a permanent and continuing nature. An instruction placing the burden upon the prosecution of proving that the defendant was of sound mind at the time he killed the deceased, based upon the conception that insanity once established was presumed to continue, was held to have been properly refused, and the court saying that no such presumption arose in a criminal prosecution where it was necessary to show not only insanity, but the inability to distinguish right from wrong, or insufficient willpower to control the defendant's action. Sounds a lot like some public official servants. In a murder prosecution involving the stabbing of a patient in a state hospital, to which the defendant had been committed by a probate court, the defendant was not entitled to a proposed instruction regarding a presumption of continuing insanity, given that the prior commitment was a civil commitment. Ooh, and where the trial court's instruction, see, it's not judicial, it was civil commitment. This is where we said here where was the one here? Let's read that caption again here. Adjudication. So an adjudication, it creates a presumption, although rebuttable, of the continued insanity. But here it's saying that given that the prior commitment was a civil commitment and where the trial court's instruction that the prosecution was required to prove sanity beyond a reasonable doubt was more favorable. Wow, okay. Oh, was not entitled to a proposed instruction. Oh, okay. Because it was civil. All right, so yeah, so indeed, the judicial, once it's been adjudicated, is insane, carries a lot more weight, especially regarding instructions to a jury, it seems, than the civil commitment. So if they're committed in a civil manner rather than by a judge. A criminal defendant was not entitled to an instruction that insanity, once having been shown to exist, was legally presumed to continue, even though the defendant had previously been involuntarily committed to a mental institution. Since the defendant did not limit his request to the particular diagnosed condition that resulted in the civil commitment. Oh, wow. You gotta be careful. Oh, boy. Holding that the trial court had erred in refusing to receive evidence of an adjudication of the defendant's insanity entered over 7 years earlier in the state. Jeez. Said it knew of no subsequent time at which the presumption ceased, of the lapse of much time during the patient had not been confined for his malady or known as a fact to be insane might so materially weaken the presumption as to practically neutralize it. Wow. So that's how you get it. After being first found incompetent to stand trial, the defendant was held at a medical facility. We read that one there. He had been magically restored. Mentally restored. Same thing. All right. Evidence of a party's subsequent conduct that his relatives and friends may be sufficient to overcome the presumption of continued insanity. The jury should be instructed that where it was undisputed that the defendant had been adjudged insane and not restored to sanity, the presumption had to be overcome by the state by competent evidence. The fact that the defendant was insane once or several times before may render it more probable that he was insane at the time of the offense, if there is any direct proof that he was insane at the time. But standing by itself, it proves nothing where the state shows a subsequent return to reason. And then, speaking of return to reason, let's get to section 297, drunkenness. Boy, we get some slim turnout tonight. Please, if you are here, hit the like. Maybe someone will show up before we're done with the session. It has been held that the habit of drunkenness, once established, is presumed to continue. The habit of drunkenness. Although there is authority to the contrary. What's the contrary? Mears versus Mears. And then McGraw versus McGraw. Less filling. Tastes great. All right. However, it has been held that it cannot be presumed that a drinking man or one addicted to the use of liquor is always drunk or always in a condition which excludes the possibility of exercising due care. In any event, it is clear that the fact that habitual drunkenness of an individual is established on a particular date does not give rise to a presumption that this habit existed at any previous point in time. It may be presumed or inferred from the fact that a person was drunk a few hours before an accident in which he was involved, that he was drunk at the time of the accident. And Section 298, the retrospective presumption, or inference as to previous condition or state of facts. The presumption or inference of the continued existence of a condition or state of facts is generally considered to be prospective, not retrospective. So looking forward, not looking back. It has frequently been said that such a presumption never runs backward. The law, not presuming, from proof of the existence of present conditions or facts, that the same facts or conditions had existed or continued for any length of time previously. Thus, the presumption of continuing insanity runs from the date of its establishment and does not run backward. It is prospective and not retrospective, and proof of insanity at a particular time is not competent to prove on the principle of natural and probable relation the same condition for a considerable prior period. There is other authority, however, to the effect that presumptions can run backward, and that a presumption or an inference as to the past existence of a condition or state of facts may be proper under some circumstances. What could those be? 61. People versus Wong. Pente, Williams Moore's Concrete Products. Okay, I hope that wasn't the Wong decision they're referring to here. All right. Whether the past existence of a condition or a state of facts may be inferred or presumed from a later condition or state of facts depends on the facts and circumstances of the individual case and on the likelihood of intervening circumstances. Likewise, the interval of time to which any such retrospective presumption or inference will be allowable depend on the nature of the thing and the circumstances of the particular case. So you can have retrospective presumptions, but boy, it looks like you have a real high bar there. Lots of case holdings here. And here we got Millman versus United States. Okay, this is Millman versus United States Mortgage and Title Guarantee Company, wherein the court said that it is elementary that the condition of a place or thing at the time of an injury may always be evidenced by showing its condition before or after that time, provided no substantial change has occurred, and added that the propriety of an inference in the individual case will depend on the likelihood of intervening circumstances as the true origin of the subsequent existence. Wow. In Henderson versus William Moore's Concrete Products, an action for injury sustained by the plaintiff when cinder blocks which had been delivered to a building site collapsed while the plaintiff was removing blocks from the pile. The court held that from the fact that the planks on which the blocks were placed were uneven on the date of the accidents, it would be reasonable to infer that they were equally uneven 4 days earlier when the blocks were placed there. Yeah, I would say pretty tricky to move those boards without moving the blocks. And that takes us to the end of today's presentation, and we'll continue next time with Chapter 13 on other particular presumptions and inferences. So, that brings us to the end of this presentation. I'd like to thank everyone that came out tonight, participated, hit the like. It was a good session here. We learned a little bit about the continuance of conditions or state of facts and where they apply, where they don't, retrospective presumptions, prospective presumptions, which are the preferred, and other factors which relate to particular circumstances and intervening circumstances of a case. So, with that said, I would like to thank you all for coming out. I hope to see you all on the next one. Peace out.